it that way. And I believe Director Bonham is going to lead off this issue, and thank you, Chuck.
Yes, thank you, President, Commissioners. What I'd like to do is take a moment, ask for your action today first, tell you why I think it's appropriate. Second, cover the timeline involved. Third, make sure we specify the issues that have both been resolved and may remain as disputed. Before doing all that, because it's been so long, I actually have to just tip my hat and extend an appreciation to what I expect could be, a variety of individuals in public comment in a moment on this agenda item. Look, for the most part, the department and everyone in the falconry community that's going to engage today have had an open line of communication, have had a constructive dialogue, and for the most part, I think we agree. There are some topics where some folks may still disagree. That doesn't change the willingness of our department to work with the individuals. Okay. My request to the Commission is that you adopt the proposed changes to what is actually an already existing package of falconry regulations today. Why? Well, for a very specific purpose. If we want to have falconry in California, you must, period. So this is not talked about much. You may not hear it as an acknowledgement and comment today, but the fact of the matter is, hypothetically, the department could have walked away and not done regulations under state law, but we didn't. The doing of a regulation package for falconry is for the express purpose of making sure our 615 licensed falconers in this state can continue to engage in their recreational pursuit in this state. So as a threshold matter, we could have said thanks, but no thanks. Instead, we've promulgated regulations so this activity can continue, and that's because the Migratory Bird Treaty Act, which is a federal law, prohibits any person from taking, possessing, purchasing, bartering, or selling raptors unless the activities are allowed by federal permit or in accordance with federal regulations. Okay. Engaging in falconry is prohibited by that act and state law unless you have a falconry license. Okay. A state that wishes to allow the practice of falconry must establish regulations that meet or exceed federal standards. State regulations may be more restrictive than the federal standards, but they may not be less restrictive. And in 2009, the U.S. Fish and Wildlife Service amended the federal falconry regulations. And the core amendment on the federal front was to no longer issue federal falconry permits. That's the conundrum for the practitioners of this recreational pursuit in our state. Instead, those federal amendments, so the federal law, requires any state that wishes to continue the practice to amend our own regulations to ensure they meet the federal standards. So we become the permitter. As you know, you adopted that original package of regulations in 2013 so falconers could continue to practice falconry in California. We don't hear about that much in this debate that's occurred in the last couple of meetings. So absent our regulations, absent our program, it's not available as a recreational pursuit. Okay, that's where I start. So let's cover the timeline. So as you know, we had the 2013 regulations in order to keep the practice alive, but most involved then also acknowledged publicly there would be a need for amendments. There needs to be a conversation for fine-tuning. That's what we've been doing since. We had an original notice of this current regulation package back in June of 2016. We actually had the noticed hearing of that in August of 2016. You had the discussion hearing in Eureka in October of 2016, and here we are today. And you gave us instruction, and I think it was spot on. Along that arc, primarily in June, you turned to the department and said, keep at it. We're hearing comment, we're hearing input, we want to think through that. We'd like you to focus in on 4 to 5 issues, right? So in late September of this year, we had a sit-down meeting in my office with the leadership of the California Hawking Club, which represents the majority of those licensed individuals, as I understand it. And we took a run at 4 primary issues coming out of your instruction. And on each of them, the department made a compromise because the input was good. First, the request was to do better, have sharper language, provide clarity on what was alleged to be confusion around the practice of the activity and possible exposure for take under the California Endangered Species Act. Check that box. We tightened that language up. Second issue, additional clarity was requested on this arena of suspension or revocation of license. Additional language was proffered. Check that box. Third, we heard a real legitimate request to think through the amount of documentation a practitioner would need. Check that box. We greatly reduced that documentation requirement in the current language. And then the fourth issue is inspections. I want to table that for a minute and come back to it. We compromised, as you asked us to engage in a conversation. And I understand, but I can't speak for the club, which may now support the language that's in front of you. Okay? To be fair, they also raised the club 2 other issues. We talked about them. The department made a judgment call. We thought they were outside the scope of what you're working on right now. One was to think through whether there's a different approach to goshawks in the Lake Tahoe area. And the second was to perhaps shift from a draw to kind of a total allowable take approach. Those 2 ideas may have merit, and we've agreed to keep them on the table and keep them going in the discussion. I know this is taking a while.
It's okay, please.
In September, we also, realizing that the club doesn't represent the totality of the opinions, extended an offer to have a conference call with important individuals in the broader community who are focused primarily on one issue around inspections. So we had that conference call. And in my judgment, based on that input on that conference call, we've actually compromised again. I'll tell you about that in a minute. So as of today, in my judgment, all the issues are resolved. The majority of falconers, as I understand it, are in support, but for one topic, which appears to still be in dispute. And I think we need to remain open to the views on this particular topic. I think it's possible to agree to disagree. But let me run through that topic. What we're talking about is 9 lines, maybe even only 2 or 3 lines within those 9, of 22 pages of a proposed regulation package. And this has come down to, I think, an appropriate but heated discussion. There are some who allege these 9 lines are the department's interest in overrunning the 4th Amendment of the U.S. Constitution, that the department is pursuing unreasonable searches and seizures, and that we're doing so in a manner that's without consent or coercion. I happen to disagree. I reject the frame that this is about ignoring our constitutional restrictions and requirements. As it's written in the text, it's about administrative inspections. Okay, so let's be specific here. And actually, we've kind of seen this movie before. In 2008, when the Fish and Wildlife Service engaged in their amendments, remember the underlying cause here is we've got to do our regulations. The feds themselves said that the falconers must, quote, submit to your state a signed and dated statement showing that you agree that the falconry facilities and raptors may be inspected without advance notice by state authorities at any reasonable time of day, but you must be present. 50 CFR 21.29 D2, subparagraph 2. The regulations also require states to certify that the facilities in the whole package meets that federal structure. And at that time, you can actually go to the code, the Federal Register, you can see the comments, you can see the response to comments. There were a lot of similar inputs about the Fourth Amendment protections against unreasonable search and seizure, and here's what the U.S. Fish and Wildlife Service had to say back at that time. Every falconry permittee agrees to inspection of his or her facilities, records, and raptors when he or she applies for a falconry permit. Because the permittee has done so, we disagree with these assertions. Inspections provided for in this rule do not violate protections of the Constitution. I'm not aware of litigation at that moment in time around that controversy, which appears to be a lot of the similar concern raised now. Okay? So, you may hear today, I understand it, claim for the department to repeat the basis for its authorities. And I'll say what I said in Eureka. Go to page 13 of the amended initial statement of reasons. The department provides 28 citations to our statute. We're not saying any one of those citations is our basis for warrantless searches. We're actually not trying to pursue warrantless searches, nor are we saying any one of those authorities is our basis to ask someone to give consent to enter their home. What we are saying is those 28 citations are our authorities to promulgate a package of regulations for falconry in this state, most of which appears to be in consensus and agreement except for this topic. That has gone to the Office of Administrative Law. They have not said you lack the authority. That has been proffered to OAL under the Administrative Procedure Act. A couple last topics. Coercion. From the department's perspective on this question of inspection, no one's being coerced into falconry. We're simply trying to create a regulation structure that can allow the practice to continue because we think it's valuable and we care about those 615 licensed practitioners. I suppose if this comes down to a question about invading one's home, which as a citizen, I care about that protection under the Fourth Amendment as well, I suppose theoretically we could prohibit people from keeping their birds in their home, but we don't want to do that. I don't see a show of force, under duress, a false assertion element of some coercion in this regulatory text. But regardless, even on this topic, we've compromised. And I think it's because we had that conference call with many of the folks most focused on this topic. Our first language on this topic was inspections in the absence of the falconer being present. We changed that because of the input. The text now requires, in order for us to inspect, presence of the permittee, the falconer. Okay. If folks are worried about a constitutionality backstop, I'd just say this was talked about in 08 and 09. We see this being worked out in the federal decision. We have lawyers at our Office of General Counsel who've looked at this as well. They're officers of the court. They're concerned about upholding our constitutional protections. Same with our law enforcement division that's looked at this. It's gone to the Office of Administrative Law. And we will always have the courts if the department is acting inappropriately. I mentioned it yesterday. We got sued for implementation of AB 96 on the ivory ban on constitutionality grounds. The court returned a verdict or a ruling that it was a constitutional law, but the courts become that backstop as necessary. So let me wrap up this way. I think even on the one topic you hear remains in dispute, we've made compromises. It's because of the input. The proposed amendments just on inspections, in my judgment, substantially move towards the position of falconers because we change the focus from the entire premises to just the facilities. That's an improvement. I think it's responsive. We now only would allow inspections when the licensee is present. That's a compromise based on the input. And this language gives the department an option to de-escalate conflicts during that contact and avoid the potential for non-consensual or intrusive facility inspections. So I'll end where I started. Long process. We're trying to keep the practice alive in the state. The majority of the dialogue, we've sorted out a consensus-based approach. There's one thing left. I think you'll hear some input on that today, but we urge you to adopt. We got to do it to keep the recreational opportunity alive.
Thank you, Director Bonham. Thank you very much. I want to also highlight what you just witnessed. Director Bonham runs a department with thousands of employees, hundreds of $million budgets, and has spent that much time and that much energy on something that affects 615, I think you said, members of our state, a state of well over 30 million people. So it's a real indication of the way he does his job and the consideration he gives to every issue that comes before him. So I think that everybody, particularly in the falconer community, owes him a debt of gratitude for the energy he's put into this. So now I want to invite public speakers up. I believe we have 9. Sherry, will you call the names, please?
Glenn Stewart, Troy Morris, Peter Stavrid, yeah, Wayne Upton, Steve Sanders, Frank Hoffman, Doug Alton, Mark Henley, and Bill Gaines.
Great, thanks, Glenn. Welcome, Glenn. I would just ask that anybody who's just endorsing a previous speaker's comments, please do that in the interest of time. But you're certainly welcome to use your full 2 minutes. But if you're just repeating or supporting, please just confirm that you're doing that. Thank you.
Thank you, President Sklar, Commissioners, Director Bonham, Assistant Director Lair, Chief Bess. I'm here to thank you for all the work, all the time that you put into this issue. As you've noted, there are only 600 of us. I represent the California Hawking Club. I'm president of the club. We have the only falconry organization with a paid membership in the state, probably the largest falconry organization in the country, state falconry organization in the country. There aren't a lot of us, so it's a big deal what you've done for us. And I'll paraphrase my comments in the interest of time. And certainly in recognition of the director's comments this morning, which really put everything into perspective. We were charged with the job of creating state regulations that fit within the constraints of what the feds gave to us back in 2009. The fact that you're willing to require that falconers be present during inspections is good for our birds, it's good for enforcement personnel, it's good for falconers. We're very grateful for it, for you going the extra mile with us. And as president of this group, we have these falconers, the members who join the group. They elect a board of directors who are charged with decision making for the group. We have about 12 board members. Today, you've got the president, you've got a former vice president, you've got the treasurer, we've got the secretary. They're right here. Our board voted to support the revisions that have been proposed today. We're very grateful. Thank you for the time to speak today. And thanks a lot for the work. It means a lot to us.
Thank you, Glenn, and thank you for your dedication to getting to today.
Good morning. My name is Troy Morris. I'm the president of American Falconry Conservancy. We're a national club. We do have paid members in California. I appreciate the comments made by the director, and I can only cover so much ground in 2 minutes, but if you care to ask me questions about how the federal regulations were promulgated and changed, I could give you some information on that. Having said that, we do appreciate the other changes that were made to the regulations. It was a lot of work, but this is an important issue. It is not only a constitutional state issue, but it is a constitutional issue. There is a statute, not one statute in the Fish and Game Code that authorizes the kind of behavior that we're seeing. Person's home, Their curtilage is protected by the Fourth Amendment. There is a fish and game code that wasn't in the announced rule, and that's Fish and Code Game 587, that says, notwithstanding any other provision of law, the status of a person as an employee does not give them the right or privilege to enter someone's private property without permission. When you require permission as a condition of keeping your birds, that's coercion. You know, I hear talk that falconry is not a right, it's a privilege, so we must consent. I hear the same thing about driving. There's a lot of rules for driving. There's laws against law enforcement searching your vehicle. If the California Highway Patrol were to put something into regulation that said that they have the authority to come to your home and search your vehicle with no probable cause and no warrant, and if not, they would suspend your license, that too would be a Fourth Amendment violation. There's just no justification for it. I do have quite a bit of information on how the federal regulations went down, so if you have any questions on that, feel free to ask.
I just don't want to let that one go. Question, I have a question for you, Mr. Morris, and you and I have talked a couple of times, and sorry, I think you caught me in the middle of
Sure.
something one time on my cell phone, but this last analogy that you just used, I mean, the fact is, isn't it true that as a licensed driver in the state of California, you do consent, you do waive your right to refuse a drug and alcohol analysis as a condition for having your privilege to drive, right? Which is a search.
They don't come to my home to do it.
Well, but you
I'm
don't
not
drive
fi-
your home. So, but, I mean, I don't know what's more personal than your body, but I guess you may think that your home is more personal than your body. I happen to think that my
There's
body
not
is
an
pretty-
expectation of privacy when you're in the public streets driving in a car. There is an expectation of
Okay,
privacy.
but
The
we're
Supreme
not talking
Court has
about reasonable
recognized that.
expectation of privacy, because we can debate that too, but I'm just saying the analogy that you use, I just don't want it to go unchallenged or unquestioned.
Sure.
That you do in fact consent, waive your right to refuse as a condition for keeping your license. I just want to make that point very clear, that when you
I don't have,
sign
there's a
your-
reduced expectation of privacy when you're driving a vehicle on public roadways, yes.
Okay, so
Doesn't apply to the home.
if we want to, so we can now talk about expectation of privacy, and I don't want to, but.
Yeah, yeah.
But the fact of the matter is that when you agree to become a falconer, the argument can be made that you understand what comes along with that, and you have notice, and so your reasonable expectation of privacy shifts because of that activity. So, I mean, that's,
I think when people took offices and agreed to obey the law, there was an expectation that they would do so, yeah.
okay, thank you.
Next speaker, please. Thank you. Anybody, just come on up. If you don't come up, you won't get to speak, so somebody come up.
Thank you, President Sklar, council, or commissioners, staff. My name is Steve Sanders. I've been a falconer since mid-'60s. I was one of the founders of the California Hawking Club in 1971, former vice president. I too want to thank you from the bottom of my heart for all the efforts that this department has done for us, not just recently, but for all of these years. It has helped protect our resource. The inspections, I think, are integral to it. In the 60s, falconry was, let's say, the possession of birds of prey was very popular, and there was a lot of abuse. Through the efforts of the Fish and Game and through the California Hawking Club, regulations have been created over the number of years, which have improved greatly the welfare of the birds and to support the sport of falconry. So I agree with the inspections wholeheartedly, and I really agree that we have to adopt this, otherwise we won't meet the federal regulations and falconry will not be allowed in the state of California. Thank you for your time.
Thank you.
Good morning, ladies and gentlemen. It's a pleasure to be here. I'm extremely impressed with the professionalism and the explanation by Mr. Bonham. It said it all. I've been a falconer in California for 50 years. I hold a master falconer's license, a federal breeding project license, and I'm proud
Excuse
to
me,
be...
sir.
Excuse
Can
me.
you state your name, please?
Beg your pardon. My name's Wayne Upton. I'm the secretary of the California Hawking Club. Just want to say thank you very much, and I believe those changes should be implemented and look forward to working with this department in the future for the future of falconry in California. Thank you very much.
Thank you, Wayne.
Hello again, Mr. President, members of the Commission, Director Bonham. Some of our members do participate in falconry, so this does affect CWA. We just wanted to thank the Commission and the Department for, again, working with the California Hawking Club and others to make sure that the new regulations aren't overly burdensome. I think the change reducing the number of documents in the field is a prime example of that. As you guys know, the rules for falconry are much more complex than other types of hunting, so we want to make sure that there's as many incentives for people to participate in falconry by reducing the red tape. I think you'll accomplish that, so thank you.
Great. Thank you, Mark. Please, any other speakers? Come on up. Somebody come up.
Good afternoon, President Sklar, Commission Board, Department staff, ladies and gentlemen. My name is Frank Hoffman, and I'm the standing treasurer for the California Hawking Club. I've driven here today from Los Angeles to thank you for your time and to tell you that as a 17-year falconer and member of our club, since before I was actually able to drive, I personally accept and endorse the adopted state regulations as amended and adopted as both an individual and the CHC board member. I realize there are a few issues that remain to be resolved and worked out, but thoroughly believe that over time and by maintaining an open, honest discussion line, know that these two can be resolved and finalized with an amiable compromise and outcome that would both be accepted by the department and the majority of falconers we serve. I thank you for your time again, continued dedication, and for gaining an appreciation of the ancient art of falconry, and for allowing licensed, compliant falconers continue this art that we feel so passionate about, and for preserving our privileges in the highest form of best practices for the health and security of the birds that we value so much and protect on a daily basis. Thank you very much for your time.
Thank you.
Hello, Peter Stavrianidakis, falconer for multiple decades, started out in the 80s, early 80s. Master falconer, also a public defender and attorney. Implied consent, give you a straight up. You first have to be arrested under probable cause of being under the influence of alcohol before you're required to submit to a test of your blood, breath, or urine. And the penalty for not is a rebuttable presumption that you were drunk. That's it. So you still need probable cause, you still need an arrest before that takes into place. So it's not just say, force me to do this, you have to have all the rest. But short enough of that. First, thank you. I want to say, Chuck, you really opened up yourself with your time and the board, and I'm not a big thank you person, but I do respect what you've done so far, I really do. During the meet and confer that Chuck hosted, I'll share with you that on 4 separate occasions, our group that was on the phone conference asked specifically, what code section, what law are you relying upon? Not once was it answered. It was demurred 4 times. We first have an Administrative Procedures Act. We talked about that briefly yesterday. Every law must have an authority be given. I've presented to you every law that you've cited in the regulations for this proposed regulation, and I double dog dare you to point to one that gives you authority to throw the Fourth Amendment out the window. It doesn't exist, and you have to have it. The Migratory Bird Act says service officers require a warrant for searches. The USFW search and procedures Right here, it says in Federal's own search and seizures manual that administrative searches are not to discover criminal activity, but to regulate the activities affecting public welfare. And permit inspections only if related to import and export activities. I'm asking you, do not adopt the regs today. Review and find those. You're obligated to show it to us, and it hasn't been done yet. You also have the letter I gave from Sheriff Vern Warnke.
Great, thank you.
It also says it's unconstitutional. Thank you.
President Sklar, members of the commission, Director Bonham, and staff. My name is Bill Gaines, working with the California Hocking Club on this issue. I think Chuck said it very, very well. There has been an inordinate amount of time put into this issue over the course of the last several months to arrive where we're at today. As Director Bonham mentioned, they've come a long way on the topic of inspections, making the change from premises to facilities, and most recently requiring that the licensee be present. That is a tremendous move in the direction of what the California Hocking Club wanted, and we're very, very pleased to support that language. Also, on documentation in the field, same answer. The department has come a long ways from eliminating a whole bunch of documentation that was in the original language that they brought forward to simply requiring license and stamps for whatever game species you may be hunting. I don't think we can ask for any more than that. One thing that I haven't heard mentioned today, and I think Chief Best would agree with me on this, I think you need to differentiate between inspections and a search. This is about inspections, not about searches. We're very, very pleased with the language that is being brought forward today by the Department of Fish and Wildlife, and we strongly urge the Commission to adopt. Thank you very much.
Thank you, Bill.
Yeah, I would ask that the commission not adopt and not vote today on...
Sir, can you please state your name? for
I'm
the
sorry,
record?
my name is Doug Alton. I represent the Falconers' Rights Group, has more members than the CHC, more California Falconer members than the CHC. And I ask that you not adopt the proposed falconry regulations today, that you not vote on them today, that you put it off until later, that you've had more time to go over these, the legal authority on this inspection language. There's one thing on the rest of the proposals that I think the CHC has done a really good job on. One word I think that needs to be deleted or at least changed, where it says the immediate revocation of the license. I think the word immediate needs to be stricken or deleted or at least changed. Those reasons are all fine, but the word immediate shouldn't be there, because those reasons are fine. You shouldn't be able to just still revoke the license 6 months later for those same reasons. The CHC themselves published a letter by Bill Gaines on their own website. There were 59 comments and umpteen replies to those comments. I counted up, it was like 99-1 against the language in the inspection, proposed language in the inspection thing, and it's not in favor by the CHC members. It's not in, the California Falconers are not in favor of this language. It's not supported. You know, Glenn's managed to find some people that he managed to bring in here to support that language, but it's not supported by the vast majority of California Falconers. I found it 99-1 on their own page.
Okay, you have to ask you to wrap
I
up.
can provide you a copy of that if you like. I've saved a copy just in case they take it down.
Great, thank you. I think that's it on speakers. One comment, well, we are not a court of law. It's, we have to depend, and we're not only one of us is an attorney. Peter.
Not a very good one.
An excellent one. I think could argue this as well as anybody. We have to depend on our lawyers and on what we've been shown and what we've researched in this process, and I think we've all looked at it a lot, probably more than on any other legal issue we have as commissioners and for me in my life. And it's clear that this is constitutional, and it's our obligation to uphold the Constitution. Forget the code. We all took an oath when we were sworn in to uphold the Constitution. I think we take that very seriously. But we're required by federal law to put these regulations into place with the very specific inspection language that we have. So we're required to, and the federal government did that only after they were certain that it was constitutional. So I support the approving as it's presented today, with the confidence that we're doing what's right and legal. Any other comments from commissioners?
Yeah, I
Please.
also
Commissioner
just
Silva.
want to compliment staff and just a great job. I mean, it's been painful, I think, in some cases to go through this, but I think it's worth it. And I think the point was well made that if we didn't have these regulations, you probably wouldn't be able to participate in that sport. So I think it's very important to get this done. And I really, again, compliment staff and want to move forward. So thank you.
Excellent. Thank you, Commissioner Silva. Vice President Hauser-Carmison.
I support the adopting the regulations as well. This is one of the finest examples I've seen in 4 years. I mean, there's been a lot, but this is one of the finest examples I've seen of Chuck and Director Bonham and the department going above and beyond, way above and beyond, to make sure that they were doing everything they could for the Falconers. In my mind, they've done a super job. I think the majority of the speakers today support that. I think there must be a misunderstanding in the ones that don't. But take a look at the federal regs again. Take a look at what the department has done and come over into the area of support, because we want them to continue to do this. We want them to work with the stakeholders. We want there to be a clear path forward for doing this over and over again. This is what I believe in, and they've done it.
Thank you. Commissioner Williams.
Yeah, at the risk of meeting the old adage that everything that needs to be said has already been said, it just hasn't
Not
been
by
said by me or everybody. Fully agree with what's been said, and again, as you mentioned, Commissioner Hauser-Carmison, the appropriate compliments to the department. Not only you did go above and beyond, and it was just sort of what we've come to expect, just because you've raised the bar so high, but to take the input from the stakeholders and work with them so hard to try to get to the right place. And then I appreciate, I guess on behalf of the commission, when we had that June meeting and we had some discussion, we raised some issues, you responded. You dealt with it. So just compliments to you for that.
Great, thanks. Before somebody makes a motion, I want to endorse everything that's been said by the other commissioners. It's absolutely all true. And I also want to compliment the Falconer community, even those who may not be happy with the vote today. The discussion's been respectful and thoughtful and sincere and in no way malintended. And so I want to compliment everybody on this process. The department's been thanked a lot, and they deserve it. But I want to thank everybody in the process for this is how it should work. And I'm really proud of to be able to vote on something that's gone this way and been discussed this way. So with that, I'd entertain a motion.
I'll make the motion that the commission adopts the proposed addendum to the final environmental document and regulation regarding Section 670, Title 14, CCR, related to falconry regulations.
Is there a
Second.
Great. All in favor? Aye.
Aye.
Any opposed? The motion was made by Vice President Hauser-Carmison, seconded by Commissioner Silva, and passed unanimously. I want to poll my fellow commissioners. We have 3 items left. I think we can wrap them up in about 40 minutes. So I would say one suggestion is take a 5-minute break and come back and finish up, or the other option is to stop and have lunch. Okay. Okay, so we're going to take a 5-minute break. We'll be back here at 10 after the hour, and we'll finish up. Thank you.
Oh, that's right.